Great. So very warm welcome to all of you to our 4th annual lecture in the laws of social reproduction. I'm Prabha Kotishwaran. I'm Professor of Law at King's College London, and I'm Principal Investigator for an EU-supported project called the Laws of Social Reproduction. So along with all of my project colleagues today, I'm really delighted to welcome Professor Adelle Blackett, who will be delivering our annual lecture titled Care Work and the Global South, Shifting the Frame on Labor Law's Founding Narratives. So Professor Adelle Blackett is a Tier 1 Canada Research Chair in Transnational Labor Law at the McGill Faculty of Law. She's an accomplished labor law scholar, and she's received 3 honorary doctorates in law. She's also the author of a wonderful book titled Everyday Transgressions, Domestic Workers, Transnational Challenge to International Labor Law, which was published by Cornell University Press in 2019, and which received the 2020 Canadian Council on International Law Scholarly Book Award. She's also the principal author of the Scarborough Charter on Anti-Black Racism and Black Inclusion in Canadian Higher Education. And from 2021 to 2023, she chaired Canada's Employment Equity Act Review Task Force, which led to a government commitment to create employment equity for Black and LGBTQ workers. So Professor Blackett is also a former ILO official, and in this capacity, she was the chief legal architect behind the ILO's 2011 Convention No. 189 concerning decent work for domestic workers. And she subsequently also prepared a draft for the Haitian Labor Code. In 2023, she was awarded the Labor Law Research Network's Bob Heppel Lifetime Achievement Award in Labor Law. And Professor Blackett has most recently been appointed Senior Advisor to the Director General of the ILO, Gilbert Humbo, where she will be focal point to the World Trade Organization, to the World Bank, and to the International Monetary Fund. And she's due to start this position next week. So many congratulations on that, Professor Blackett. So as you can see, she is an accomplished scholar, she's a teacher, she's an activist, and she's a visionary who's had impact at several layers of labor law, be it in the Canadian domestic context or at the international level. And we had planned this lecture for a very long time, in fact, but due to diplomatic tensions between our countries, we could not actually host her in person in India. But nevertheless, we are delighted to finally hear her today. We are also delighted today to welcome Dr. Neha Vadhavan, who is at the ILO in New Delhi and who will moderate Professor Blackett's lecture. So Dr. Vadhavan, as National Program Coordinator of the FCDO-funded Work and Freedom Project, has led efforts since 2018 to prevent trafficking of adolescent girls and women into forced labor, focusing on domestic work and garment supply chains in South and West Asia. As part of this program, she promotes knowledge sharing on labor rights across regions. Dr. Vadhavan holds a PhD in international politics from JNU with research interests in social protection, labor rights, mobility, and gender in South Asia. And she's worked with several UN agencies and the governments of India and Nepal on socioeconomic development, on labor migration and women's work, and she has previously taught at Ambedkar University in Delhi. So before I hand over to Dr. Vadhavan, I just want to remind you that you're very welcome to share any comments and questions in the chat section of the call. And our Twitter handle is at Laws of Social Rep. And we are really, really delighted today to welcome both Professor Blackett and Dr. Vadhavan. Over to you, Neha.
Thank you very much, Prabha. I'll just join you in welcoming everyone to this special lecture, and how much I know that I am looking forward to listening to what Professor Blackett has to share with us today. So I think Prabha has already given the introduction, so I won't waste much more time. And I'd invite Professor Blackett to please deliver her special lecture. Thank you.
Thank you very much, Dr. Vitawan. I am deeply honored to deliver this fourth annual lecture in the laws of social reproduction. And I'm even more honored because my esteemed colleague, Professor Prabha Kotishwaran, director of this research and leader in the field, extended the invitation to me, as she intimated, longer ago than I care to remember, and then has been extraordinarily patient as we've navigated along with her formidable team. I want to thank Amy Hart here as we've navigated the unanticipated diplomatic territory and then the implications of my appointment. And although I haven't started my appointment here, just to be abundantly clear, I am speaking in my personal capacity and not on behalf of the ILO, and nothing that I say can be attributed to the ILO. And in fact, indeed, even as I was working on Convention 189, or what would become Convention 189 and Recommendation 201, I was working as an independent expert for the ILO. Anyhow, um, I, more than perhaps anyone, regret that this lecture isn't happening in Delhi. It is very cold here in Montreal, but it's happening, and I'm grateful. So today I'll be talking about research that was not undertaken yesterday. This research is in many ways the research of a lifetime. It's close to my heart and to communities that are close to home. While it surrounds the work undertaken to establish what is now the historic Convention number 189, it has always been more than that. It has been about taking the work of social reproduction so seriously that we understand it as transformative for labor law itself. It affects labor law's founding narratives, and that is the theme on which I wish to address you today, essentially emancipatory approaches to labor law. So domestic work is work like no other, and work like any other. This was the rallying cry that surrounded how we sought to shift the narrative on workers and work. The workers who W.B. Du Bois characterized in relation to people of African descent who predominate in the work in the United States as, quote, a despised race in a despised calling, end of quote. And as we are increasingly learning, Dr. Ambedkar was in correspondence with Dr. Du Bois and acknowledged the deep similarity between those referred to as the Dalit caste in India, who have typically been relegated to domestic work, and the position of African Americans. And in Dr. Ambedkar's work, in his letter to Dr. Du Bois, the study of the latter is not only natural, but necessary. So I'd like to take that insight even further in today's talk because it's a fitting reminder that the Global South is as much a conceptual framework as it is a geographical label. It's a framework that begins to allow us to grapple with what it means to emancipate ourselves from a vision of our legal fields that implicitly but powerfully shapes, even contorts, how we understand our disciplines in various parts of the world. And in this case, in relation to labor law, I argue that shifting the frame that we need to undertake in labor law is then necessary conceptually in both the global South and the global North. And I go further to claim that the most human of activities, that of care, helps us immeasurably in that shift. And so I go further still. The shift happens through the global South and through racialization and labor migration in what is referred to as the South of the North. The movement is multi-directional and transnational. I acknowledge that focusing on the example of domestic workers to operate this kind of conceptual shift may seem counterintuitive. These workers face historical marginalization, workplace isolation, despite their omnipresence in global migration. They fall outside of the paradigmatic worker that has been at the core of dominant conceptions of labor law. Yet domestic workers have been at the forefront of a subtle, but frankly unmistakable shift, including on the part of the ILO. And this has occurred in the following three ways. First, through a focus on an entire protective framework of rights, commensurate with the move beyond a narrow articulation of what it means to be legally in an employment relationship. And you'll recall master and servant law is essentially a law of the household economy to move to one that moves us past informal employment relationships. Second, through an emphasis on domestic workers' exercise of agency, something that's often articulated, but the domestic workers themselves insisted on foregrounding beforehand throughout the standard setting process and in the implementation of any ameliorative agenda to ensure that, in fact, the agenda was transformative. And third, through an insistence on the need to understand this work as transnational work, and through that process to understand the transnational in its specificity. Of course, domestic work, and in particular migrant domestic work, is our most immediate conduit to understanding the transnational in this context. But if the pandemic has taught us anything, it is that unless we are focusing on social protection, not protectionism, but social protection, and on creating the transnational conditions to raise the working conditions of the most disenfranchised, we're missing the call. So while it's beyond the scope of this lecture to engage with the powerful scholarship led by Professor Kotishwaran on sex workers and the politics of anti-trafficking discourse that persists in enshrining a form of sex work exceptionalism, I do want to take the time to acknowledge one of the many points of convergence in our work, including a deep distrust of so-called redemptive capitalism and close rootedness in how we understand exploitative labor market conditions across a wide spectrum of work. What I wish to underscore today is Professor Kotishwaran's acknowledgement of the need to engage in a thick, sustained way with global heterogeneity in the quest not to flatten out the world between abolitionist or neoliberal legalization strategies, but rather to ensure a form of regulatory sophistication that emphasizes the redistributive questions that centers them in this work. So this preoccupation has been at the heart of emancipatory approaches to labor law, work that at once insists on preserving space for workers' autonomy, which can mean both acting without the state and holding states accountable for literally holding open the space for autonomy. I'll suggest that this accountability for action increasingly must happen across across states, across multiple states through forms of multilateral governance in this area. So let me now turn to the forms of regulatory innovation that were so central to the establishment of Convention number 189 and the accompanying non-binding supplementary recommendation number 201. I'll discuss three. First and foremost is the case of South Africa itself, which frankly inspired the ILO's governing body to support standard setting on this topic in the first place. So we're now in March 2008 when the item came onto the agenda as a potential topic amongst others. It was not necessarily the most obvious choice. That is an understatement. Sure, the ILO had been seized of the issue of standard setting on domestic workers, frankly, quite soon after it was established in 1919 from a 1936 convention on holidays with pay that exempted domestic workers, but saw a resolution to consider putting the protection of domestic workers on the agenda for future sessions, to a 1945 mention of domestic workers in a standard on child labor, to a 1948 resolution concerning holidays with pay for domestic servants, in which the ILO noted that it was the duty of the ILO to extend the benefits of international protection to domestic workers, and to a 1964 resolution concerning the conditions of employment of domestic workers that cited, not without irony, the urgent need for standards compatible with the self-respect and human dignity, which is essential to social justice for domestic workers. So the issue was repeatedly before the ILO, but without action. And without action because the paradigm shift required in an understanding of labor law in order to include domestic workers was greater than the approach to understanding who could be the subject of regulation and how was in place. So it was with the South African Minister of Labor, who told the governing body, literally, that his own mother, like the mother of so many South Africans who had been a domestic worker under apartheid, told them that domestic workers, one, had been central to the liberation movement, so actors in their own right, and second, that on the eve of the end of apartheid in South Africa, politically, South Africa had managed through constitutional and legislative change, which came to be known as transformative constitutionalism, to make significant strides on changing the relationship from one that epitomized apartheid to one in which domestic workers had rights and dignity at work. Those changes, as the Law and Practice Report chronicled, included not only establishing basic conditions of employment that deemed domestic workers to be employees, addressing hours of work and a range of living conditions, and ultimately framing minimum wage protections, which, although relatively low, have been the field for battle, basically, for improvement. They also included a creative, accessible approach to dispute resolution, one that through the Commission for Conciliation, Mediation, and Arbitration has tended to mean that a domestic worker who's terminated from her job in the morning can show up in the afternoon and in a few weeks find herself sitting at a table looking out at her former employer, telling her story in her own words, even in her own language with the support of a state-provided interpreter, and receive a settlement, some money, some semblance of justice, and possibly some ability to look her employer straight in the eyes. I had the privilege to observe some of those mediations. And although I was not there when the South African member of the governing body of the ILO spoke to the constituency,
Hi, Nick.
I understood the power.
I'm fine. How are you?
I understood the power of change of which he spoke. And I did get a call very soon after, when, to the surprise of many, the item came and became the choice of the standard setting, and for a full binding convention and recommendation at an organization that had not set a full binding convention in years. So South Africa's role throughout the 2 years of deliberation at the International Labour Conference of the ILO in 2010 and 2011 was pivotal and repeatedly informed the debates as the delegates considered the magnitude of the transition that they were undertaking, redressing the asymmetrical law of the household workplace in favor of decent work for domestic workers. They came to understand that this was indeed possible. So we'll come back to the South African example and what shifting the frame actually starts to feel like in a society that has changed so much, but where so many born free still overwhelmingly rely on what is still low-paid domestic work and still live the spatial differentiation across the economic divide. How much can the frame be shifted through labor law? But let me turn to the second example that was pivotal, and it emerged out of the experience in Uruguay, which had tackled the challenge of how to address the pernicious issue of labor inspection in the context of households. What, in other words, did it mean to state that the household is, in fact, a workplace? How does this force us to engage with the state? It's tended to be a primary casualty of this field, a resistance, in other words, to seeing the household as somebody else's workplace, a resistance, though, that so much feminist theorizing has helped to break down in the context of understanding domestic violence. So in the family context, we butted up against another form of resistance, and that was the resistance associated with state incursions in the household in the context of autocratic states. And so how does this play out in the context of the household as someone else's workplace? So even though the ILO's convention on the topic, the Labor Inspection Convention number 81, and the Protocol of 1995 to that convention should cover domestic workers, privacy and inviolability of the home were repeatedly raised as barriers during the International Labor Convention's deliberations. The Law and Practice Report addressed the question squarely. Respect for privacy is important, but need not result in an absolute bar on inspection visits. And relying on the ILO's own committee of experts that had opined on this matter, the consent of the employer or occupant of a household, or prior judicial authorization ensure respect of the principle of privacy while balancing this with workplace rights. But it was ultimately Uruguay's prominent role at the time permitting labor inspections where there's a presumed violation of labor and social security laws, and its measures to form literally a specialized section in charge of monitoring provisions for domestic work that became central. This included strict limits on nighttime inspections, judicial authorizations being required for daytime inspections, and its overall balance struck that is ultimately reflected in the text of Convention number 189. So a third example comes from India. And let me preface this by stating that, of course, many an example of legislative and policy reform from India has been pivotal to thinking through, in particular, the provision of social protection and the move from the informal economy to formalization of domestic workers' rights through a comprehensive creative approaches to social welfare protection. Many in the audience are better placed to inform me on those examples than I would be to speak on them. But what I'd like to focus on is an historical example that may be too readily overlooked or maybe thought of as far from how we conceptualize social regulation, or the kind of social regulation that's typically centered in the work on law reform and legal change. But that is, of course, the point of this lecture. I want to reference the impact of broad forms of resistance, and through them, the affirmation of domestic workers' agency that we have not been able to take for granted. You see, a big part of the surprise about having domestic work as a subject of international labor regulation has been the perception, or let me say, I think I can actually say was the perception. I think we've moved, was the perception sometimes, but not always put into words, that they were not really workers. Certainly not the paradigmatic worker. They were rather like one of the family. I've spent a fair bit of my own time explaining that once you need the modifier like, you've basically confirmed that what you're talking about is an older form, the household economy, where domestic servants or slaves were very much central, but not as family members. They were slaves or servants, part of the household economy, part of the relationships of subordination that framed, frankly, Blackstone's articulation of the relationship. So we've retained the vestiges of these older relationships, just as we have largely retained the vestiges of the law of master and servant. So India then, the New Delhi-based All India Domestic Workers Union, which started mobilizing in 1953, and whose members held a 26-day hunger strike to seek legislative reform, and who in the process sponsored draft legislation to improve the rights of domestic workers as early as 1959. I emphasize the hunger strikes because they offer a broader, more capacious way to be thinking about what it means for workers to organize, to exercise agency, and to seek to defend their collective rights. It shifts our frame in a manner that keeps our focus on the multiple ways in which workers exercise agency for themselves. So what we saw through the advocacy and negotiation of Convention number 189 is that domestic workers claimed the front lines. They shaped the narrative around the standard setting. They successfully lobbied the ILO to adopt new standards. They immediately celebrated and drew attention not only on ratification, but on seeking further constitutional and labor law reforms. They basically sought to unsettle societal practices of inequality that directly affected them and societal perceptions about their work that they underscored is the work that makes all other work possible. So they've been at the forefront of litigation, reaching some of the highest courts across world regions, fundamentally shifting understandings of their inclusion. So look, there are many more examples of how decent work for domestic workers has essentially become a counter-hegemonic transnational legal order. Certainly, Convention 189 has been ratified by 38 states across all world regions, including both countries with high internal and historical populations of domestic workers, countries that have sent domestic workers abroad, countries that have significant populations of migrant domestic workers. But there's more. And in a neoliberal economic order, the ability to unsettle historical forms of subordination has been a rare and at times sparkling counterexample to a cemented vision of social change. But it would be perilous to end the story there, of course. And the palpable, painful backlash, for example, and I'm picking just one example, the destabilization of constitutional and legislative change that combined social welfare provisions through a Bolsa Familia for domestic workers in Brazil. And according to some, that the magnitude of that change, domestic workers, that enabled domestic workers literally to say no, amongst other things, to living in with their employer, The magnitude of that change was considered by some to be a significant factor in Jair Bolsonaro's presidential election before, of course, current President Luiz Inácio Lula da Silva's return to power. So look, this backlash could be the subject of the entire lecture. So I'm going to just ask you to take backlash when a subordinating legal order is disrupted as a given, and move instead to a key observation that holds even through the backlash, and that is that one of the elements that was and remains central to the work of establishing Convention number 189 is that the regulatory innovation came essentially from the Global South. Now, truly, this should not even have to be said. Building an international convention from a vision of what matters in labor law, from what emerges from the Global South, was and remains a significant shift from a vision that assumed that our labor law frameworks were necessarily of and from the Global North, of and from a narrative that situates the trajectory of the field as commencing with industrialization, focusing on an archetype of industrial man that shapes how we come to understand labor regulation and literally leaves any question of how the wealth and financing of the Industrial Revolution and the accumulation of wealth behind. So let's call it, for shorthand, a form of modernization theory of law or labor law. Its power was that this did not have to be named. Focusing on domestic workers for standard setting then meant shifting a frame to engage with the persistence of a form of work in the care economy that was supposed to be a relic of a forgotten past that was supposed, with a particular form of industrial modernization, to have disappeared, or in any event, to have been disappearing, right? Close attention to the care economy and to labor market stratification allows us to distinguish between strategies that invisibilize the very form of labor that sustains us, while relegating that work to those whose subordination is far from questioned. This gets naturalized. So standard setting on decent work for domestic worker goes some way toward unsettling that starting point, and the need for the standard setting itself in the face of a reemergence of significance of care work, including migrant care work, was the further reminder of just how challenged the modernization theory as applied to labor law has been. So how is that? Briefly, labor law's subject has to be rethought. In my book, I chronicle how that realization slowly but surely started to sink in, so much so that by the second year of discussions in Geneva in June 2011, it was actually the employers group representative who started to make the case for why this historically marginalized group performing this historically undervalued work actually had to have a minimum wage, at least commensurate with the general minimum wage, as a basic issue of human rights. So labor law, in other words, was being regenerated from its margins. It's important to consider what we mean by margins if we are to take a starting point from the Global South and the South of the North seriously. And I'll do this here all too briefly, because what needs to be done is to think about labor law and its relation to colonialism, and in particular settler colonialism, how the dispossession necessary to secure land and resources also entailed extracting colonized people from their land and their traditional ways of being on that land and replacing them with the migrant rural to urban or across partitioned states, but dispossessed a stranger in his or her own home. Labor law in the colonies gave the migrant, recharacterized as modern industrial man, but often a domestic servant, only limited features of so-called industrial citizenship, sometimes, as for domestic workers, just a bed in or near someone else's home. Although there has been some scholarly engagement with the fraught project of building a limited native labor code that the ILO embarked upon soon after it was established in 1919, we have not quite revisited the extent to which the narrative have become controlling. This is true even as we increasingly recognize and engage with the history of colonialism and slavery as intertwined global histories. Moreover, we have not quite engaged, as First Nations Dene scholar Glenn Coulthard recognizes in his work on Frantz Fanon, misrecognition will remain subordinating in the broadest sense if it does not entail engaging with the subjectivities of the historically dispossessed. So this is a long way of affirming that it is by focusing on the margins of labor law, steeped in rather than residing untouched by a colonial frame, that the tendency to misframe labor concerns as naturally necessarily domestic governance matters becomes particularly problematic. In other words, legacies of slavery and colonialism so deeply imprinted on the way that domestic work is regulated should help us to be able to call into question an insistence upon understanding labor governance as a purely domestic matter. This becomes all the more unavoidable when we consider the sheer scale of the phenomenon of contemporary migrant domestic workers who undertake the perilous navigations across borders around the world, only to wind up in the households deemed private and framed as beyond the reach of any state. This calls invariably for focus on the failure to address labor through transnational governance, like labor migration or the movement of persons often to work. Like labor migration or the movement of persons often to work is primarily misframed as a domestic governance matter. And Convention number 189, although it has the distinct advantage of applying to all domestic workers, whether they are migrant or not, and to apply special protections, especially on recruitment agencies for migrant domestic workers, in no way does it call into question the national paradigm, or for that matter, the reliance on temporary migration programs to address care deficits. Care work extraction in Russell Perennis's terms predominates. Care, rather than being reincorporated in the framing of what we all do as humans, has become externalized, while the racialized pattern of who does the work remains historically laden. Those patterns, far from humanizing the relationships of work, serve to normalize structural inequality. So did the standard setting to regulate decent work for domestic workers offer limited space to engage with order crossing? Here I move deliberately to the specific. That is paragraph 26 of the non-binding but supplementary recommendation number 201, which encourages states to, and I quote, take appropriate steps to assist one another in giving effect to the provisions of the convention through enhanced international cooperation or assistance or both, including supporting social and economic development, end of quote. Does this provision help us to take the direction of thinking transnationally? Does it embrace forms of international solidarity? Does it bring us closer to labor law as development? If ever there was room, there is simply no more space to be romantic about care and about paid domestic workers in this pernicious world moment, where in Judith Butler's terms, hate has been emancipated. It is even, frankly, hard to have this conversation, much less believe in its possibility. Law reform is fraught. All I can muster is that it may be that it is precisely in this world moment where it's crucial to be harnessing the capacity to think and act differently rather than cower, to arm ourselves with the institutional courage to reimagine our paradigms. This includes doing the hard work of building international or transnational social policy into multilateral legal architecture, identifying the spaces for redistribution transnationally. What happened For all of the talk of the need to build social protection floors that include domestic workers, for example, to the attention that was starting to be placed, particularly during the pandemic, on and including in the Sustainable Development Goals, to financing that social protection multilaterally and through multilateral mechanisms. So none of this is really a new project anymore. And it's an increasingly necessary project, one that both depends upon and is part of how we build international solidarity. Reclaiming regulatory capacity in the various spaces where economic governance is operated to craft social justice alternatives is as much an act of legal imagination as it is a tremendous policy coherence challenge in which the ability to act as a counter-hegemonic whole will be larger than any individual atomized part. To get there will require us to be deliberate in acknowledging the weight of history on relationships with the global South conceptually, which includes the South of the North, and to make it a priority to do the work of decolonizing labor law collectively and transnationally. So what has this to do concretely with those domestic workers who almost 14 years after Convention number 189 was jubilantly adopted are still overwhelmingly historically marginalized, where the 19th century words despised race in despised work still applies to the persisting and particularly abject exploitation, where domestic workers still risk their lives when they cross borders, still struggle to make a bed their home in someone else's household. Is focusing on domestic workers as the way to rebuild a renewed labor law perilously utopian? Should our shift instead be toward that of abolitionist thinking beyond labor law? You know this. Abstraction holds inherent perils. So I must return instead by ending where I began. And that is in the messy, rooted vision of an idea of labor law that can only sustain emancipatory aims if we are taking extremely seriously the significance of cultivating any redistributive goals through forms of emancipatory self-recognition through representation. Put simply, domestic workers must lead, as they did in calling for and then vigilantly insisting on the framing of Convention number 189 and Recommendation number 201. Domestic workers themselves must have the space to frame their social justice claims, to work through what an emancipatory labor law looks and feels and tastes like to them. Thank you.
Thank you very, very much, Adele. That was really, I think that was really a very, very interesting and thought-provoking lecture. And I can already see a few hands coming up. But I will take the opportunity that I've been given very graciously by Prabha and the Laws of Social Reproduction Project to moderate the discussion, but also perhaps share a few reflections based on the work that I have been involved with at the ILO, based in the Global South, in a place like India. Now, I just think, I think C189, first off, is really a weapon of the week. And I think it's been really, I think, amazing to have this tool, which has empowered, I think, thousands and millions of workers across the Global South. And I think the examples that you talked about also present, I think, the different challenges, but also the influences that play in the way C189 sort of really came about. And I think, the fact that you highlight, which is these are really carefully and consciously negotiated text. And the amount of work that goes into each convention, and especially C189, where we really heard a lot of domestic workers, representatives, and themselves, I think, come forward and talk about the challenges they face and the rights that they demand. I would like to actually draw your attention to a few issues or challenges that we have faced in the way we have read 189 in the context of South Asia, particularly, right? Now, we know that domestic workers are not a homogeneous set, that live in, live out, part-time, full-time. And like you rightly said, I think if workers are given a choice, they would like to live out and work, right? In your book, you mentioned that. And I think in this context, again, it feels to me that while the convention sort of course, talks about all different types of domestic workers with different kind of employment relationships, there is, of course, the effort to highlight and understand the challenges of the most vulnerable and the most marginalized. And therefore, a lot of the interpretation in terms of labor law, or when we talk about sort of negotiations between sending and receiving countries, we can see that this is really in the paradigm of migrant domestic workers and full-time live-in domestic workers more so, right? What gets ignored perhaps is the different ways in which domestic workers have created different arrangements of employment for themselves. And I'm talking about, the phenomenon of, say, free visas, right? Where domestic workers go as, of course, a kafil, right? In the Gulf context, where they migrate based on the employer's arrangement that they will be working for a particular employer. But in the context, again, of, say, economies which have been struggling, you can see that even employers have different types of short-term arrangements that they have created with workers. And somehow, this flexibility of how workers themselves, I think, innovate in terms of making their working conditions better is something that we are not able to bring in, to the negotiations between countries and when we talk about migration governance broadly. Another challenge I feel is that in the case of the Global South, because there is so much of employment that women access through part-time domestic work, it really, I think, overwhelms or, plays really a majority role, right, in terms of how we then view domestic work. So what's interesting is that when we look at the national labor governance paradigm, we then see migrant domestic workers being invisibilized, not, I think, by sort of organizations really wanting to do that, but in the narrative, and because, a lot of domestic worker trade unions are actually having members who are part-time workers, they're also easier to mobilize, easier to organize, right? So the bold voices that you hear about domestic workers is really about part-time domestic work. So I think it's been a challenge within the national governance framework, especially in the case of a country like India, where it is seen that migrant domestic workers, especially overseas migrant workers, are really few in number. And the large majority is actually part-time live-out domestic workers. So how do we really sort of approach the issue while trying to balance it? And it's been a really sort of uphill task, trying to, talk about legislation at the provincial level and at the national level, where both categories are sort of brought in and balanced. And I think and again, C189 really sort of helps point to the right directions. But this is, I think, it's sort of not settled, right, in terms of how these two categories engage and what sort of focus we must make in terms of addressing their concerns via labor law. The other issue that I wanted to sort of really share with you is the whole concern about protection, right? And you mentioned it in terms of how we must make efforts and how states must make efforts to protect domestic workers. It's there in the convention as well as in the recommendations. But what we see really is a lot of discourse around the challenges workers face when they migrate for work is around recruitment costs, right? And there is a focus, therefore, on trying to reduce these recruitment costs. What we've seen over time, and I would say since the convention came around till about, more recently, what we could see in the field, is that as the ILO, we've been promoting the employer pays principle and fair recruitment initiatives. But with employers paying for recruitment costs, we can also see an increase in probation periods of migrant domestic workers, right? So again, I think the challenge becomes here that how do we really look at the issue of recruitment and costs related to it, while being able to also understand how certain principles, if applied without using a gendered lens, can actually not benefit women migrant workers in being able to access decent work. And of course, there's the whole issue of bans which have been imposed on women's mobility in the name of protecting migrant workers, women workers, which would have never been done had it been male workers who had been found to be exploited or not being able to access basic working conditions, right? The other issue, I think, with intermediation is that I think we really need to focus on it. And of course, again, in C189, there is mention of placement agencies and the kind of role that they must play. But I do feel that in a context where you also have several sending countries that have not ratified C181 on private recruitment agents, on private placement agencies, the convention, right? Or any of the migration-related conventions. Sorry, I think I was muted somehow. It's become a tall ask to really understand how one can really talk about intermediation from the perspective of domestic workers' rights, where we then do not throw the baby out with the bathwater. And I'm saying this because a lot of women actually depend on informal intermediation to access better jobs, right? So this has really been, I think, a big challenge in terms of how we've looked at some of the work that we've done. And finally, I'll end by just saying that given, I think, the decade of work that went before C189 came around in the context of South Asia, and after C189 sort of came in, right, there's been a huge momentum that has been built. And we can see this very clearly in the recognition, not as workers or as eligible for minimum wage, perhaps, but definitely in terms of access to social protection, that governments are trying to recognize the role of domestic workers, right, in our countries. Having said that, now as we move towards looking at the care economy, this brings me to a certain conceptual and definitional question, which is that C189, as I understand, also included workers that were doing gardening or driving or, other household tasks, right? And it's been really interesting to note that because these sectors, and I think there are historical reasons why these sets of workers actually have access to greater levels of formalization and greater levels of rights, right? Do not want to associate with domestic workers to begin with. Now, when we have a broadening of our approach to bring in education and bring in health workers into the care work framework, how really are we going to deal with these different definitions and categories, right? Especially since some of the borders of these categories are porous, right? So it's really, I think, a challenge, and I'm just thinking aloud when I'm saying this, because, to really wrap our minds around the idea of ensuring fundamental principles and rights at work for care workers, how do we balance or how do we build on the momentum we've built for domestic work and their rights, workers and their rights, without, losing losing a certain momentum that we've gained with this broader framing that we are sort of engaging with. I hope I've been able to communicate what I'm trying to say, right? But these are just some initial thoughts, and I'll stop there. I don't know if there are any questions from the audience, but as we wait, Adelle, would you like to respond to some of these points and then perhaps move to questions? Okay, thank you.
Thank you. So very briefly to express my appreciation for them. And I am moved by your characterization as weapon of the weak. I think domestic workers have drawn on Convention 189 both as a sword and a shield. And your framing of how is extremely helpful. Let me start with your last comment because it's so evocative, and it's a reminder, right? I've seen this as I've moved in different contexts around who was considered a domestic servant in colonial context, and the approximation then of the industrial ideal. And then secured certain protections, and then how with an increased gendering of the work changed. And so as I was looking at the 1959 draft legislation, the bill, and the Hansard kind of discussions of it, one of the comments was that the domestic workers who were seeking inclusion in this legislation might do gardening and then do some domestic work. So to your point about the porosity of the borders, this has not new. It's very much characterized the work, and it's part of the thinking beyond a definition that maps onto a narrow understanding of particular workers' social location, right? It is precisely in claiming the broader field and even claiming the language of care work itself, when some would have preferred to separate what Dorothy Roberts refers to the spiritual from the menial characters of this, but no, to claiming a comprehensive understanding and then working through the messiness of that, right? And that becomes increasingly important as one is talking about social protection frames and how you draw a broader range in. I am intrigued and excited, frankly, by your comment about the various ways in which domestic workers are mediating a range of relationships across different contractual form and indeed different migration form. And all I would say there is we just need so much more granular research. And I know your team is doing a phenomenal job kind of leading much of that work. The convention, when it was being negotiated, we were told at some point that it should just be, very vague. It should be a bit of a charter of rights. Domestic workers have the right to freedom of association or whatnot. And we're like, well, that's not actually going to get us past where we have been, right? We need to be granular. But in many ways, a text of this nature can only ever point the direction, and then the working out has to happen locally and in context and has to be informed through communities of learning as to what is actually happening. And this is where I invariably wind up ending, even as I find it maybe not enough, right? Maybe a bit of a cop-out to say domestic workers must lead, but I also think it's fundamentally right? They tell us what they need, and need to be able to mediate, to work out the mediation themselves. And so, very last comment on the informal intermediation. I think that follows. One of the probably trickiest pieces of the book was to suggest that when we focus on formal versus informal, we might actually be missing the point. and that, sure, formalization, if you will, but really what we're talking about is shifting norms that incarnate forms of colonial power. And if we're talking about transforming the laws of the household workplace, it doesn't mean that we're formalizing everything necessarily. It means that we are shifting the frames, shifting the relationships, right? Refusing that the terms of the relationship are already so deeply intertwined with domestic workers' bodies, right? That we're operating what is ultimately a fundamental and I'm resisting simply flattening this out as identity, but we're there's so much about the quality of the shift that has to take place to be able to affirm that the work is not to be restricted to those who have been socially and economically subordinated, right? And so that kind of work has to happen as much through informal intermediations, but that have and continue to shift the kind of power relation that's always been inscribed in this work. So when I talk about shifting the narrative, I mean that quite literally and quite fundamentally. And I am struck by how a commitment to rethinking social protection more broadly helps with that capacity to focus on domestic workers' own agency in bringing those shifts into place.